All right, it is just about 2 past the hour. So, in the interest of using our time expeditiously and wisely today, I would like to get started and welcome everyone again to another California Policy Forum event. Today, our topic is guidance for nonprofits and foundations facing federal pressure. My name is Robert Gibbons. I'm the Director of Education here at Cal Nonprofits. And the California Policy Forum, for those of you who are maybe new to this event, is a collaboration. We put on quarterly webinars, mainly focused around policy issues affecting the sector here in California and nationally. And it is a collaboration between SoCal Grantmakers, Philanthropy California, the League of California Community Foundations, Cal Nonprofits, and Northern California Grantmakers. With that, I'd like to do a little bit of housekeeping. I'm sure everyone is very well versed in using Zoom. It looks like everyone is using the chat very well. So great to hear from everyone there. I would like to note that there is also, in addition to the chat box, a Q&A box. And this is where we're going to ask you to place your questions for the panelists. We'll do our best to be monitoring these questions. And if we're able, we'll answer them as they arise. More than likely, we will save them for the Q&A session that we have some time set aside for at the end of this webinar. But keeping those questions in the Q&A box as opposed to the chat really helps us filter through them and keep them top of mind. Otherwise, they can sometimes get lost in this chat. And this is just another opportunity for me to say, this webinar is being recorded. Everyone will be receiving a recording of the webinar, as well as a copy of all the slides and the resources that we're going to reference throughout the presentation. Additionally, there is a closed captioning feature. That's the CC button down at the bottom of your Zoom screen. So if you would like to follow along via chat or text, you can enable that feature to do so. And with that, I would love to bring on our panelists and Laura Simon, the CEO of the League of California Community Foundations, who will be moderating our conversation today. So Carl,
thanks, Robert.
Laura, take it away.
Thank you, Robert. Thanks, Cal Nonprofits and all the partners on this series. I am Laura Seaman. I have the privilege of representing the League of California Community Foundations, which is our statewide coalition of place-based community foundations, collectively serving the counties where over 99% of Californians live. Another show of gratitude for the collaboration of our partners on this program, which, as Robert mentioned, is an ongoing quarterly series. So stay tuned for future topics and always feel free to let us know what kinds of issues you'd like us to lift up on this forum. And a special thanks to the hundreds of nonprofit and foundation leaders with us today who registered and will be watching on replay on this important topic. I'd like to introduce our topic a bit more and our speakers, and also to moderate what I know will be a robust Q&A discussion, because today's session is called, as Robert shared, Guidance for Nonprofits and Foundations Facing Federal Pressure. We're grateful for the chance to use this forum to lift up two important voices of legal expertise in our sector who bring a deep experience representing and guiding social impact organizations of all stripes through really all manner of regulatory issues, public policy shifts, and legal challenges for many years. We'll be joined very shortly by Shirley McLaughlin of the law firm Adler and Colvin, who brings a rich background in community philanthropy and in nonprofit compliance. Shirley will take us on a bit of a guided tour on the top issues and challenges that she and her team are helping their clients to navigate these days, and she'll help us to focus our attention individually and collectively on the most practical tools and strategies. We'll then also be joined by Carl Mill of Mill Law Center, whose mission is to provide the nonprofit sector with a new approach to legal services that's innovative, cost-effective, and responsive. Carl will give us a first look at the new Defending Equity initiative spearheaded by his team, and this is a pro bono legal service for 501c3 charities that have been targeted or will be targeted for their DEI work, their support of immigrant communities, or similar activities. Our big goal today together is to translate some complex federal laws and actions into clear and actionable guidance, helping you to identify key legal red flags, to implement practical strategies to protect your organization, and really to navigate compliance challenges and mitigate risks so that you can continue to deliver on your mission in service of community. Our disclaimer today is that this is an educational webinar intended to provide a high-level overview of the areas that you as a nonprofit or foundation leader will likely want to focus your attention. It's not direct legal advice to your organization, for which we always recommend that you seek out legal counsel directly. So with that, let's get to it. Nonprofits and foundations are increasingly navigating a fast-changing and sometimes bewildering political and legal landscape between steep federal funding cuts, funding freezes, a new tax policy framework, a slew of executive orders that continues to this day, and in some cases, congressional investigations and direct legal challenges to their work. Whether your organization has been directly impacted by federal funding cuts or targeted by direct legal challenges, whether you're part of a coalition that is navigating these pressures on behalf of community, or whether you simply want to be better informed and better prepared, this session is for you. So with that, I'm going to welcome our first speaker, Shirley McLaughlin of Adler and Colvin. Shirley, the floor is yours. Thank you for joining us today.
Sure. Thanks, Laura, and thanks, everybody. It's so nice to see a bunch of familiar names in the chat. So thanks, everybody, for being here. Some of you might have even heard me give some of this talk before, because as you can imagine, there are many, many people who are struggling and trying to figure out, what is it that our nonprofit needs to know in this crazy time, very dynamic time, right? Things are changing all the time. I had a discussion with somebody yesterday where they said, so are things, really as busy now as they were, earlier in the year? And I said, well, things are different now. And they said, isn't that just the motto of 2025? Things are different now. And I had to agree with them. So what I'm going to do today with Carl's help actually is I'm going to spend a little bit of time just talking about current threats, right? What are those federal pressures that we're seeing and how they're affecting nonprofits? I'm going to do a brief overview. I'm not going to spend a ton of time on the legal nuances. I'm going to mention them. I did provide some handouts. So after the call, you'll get, as Robert mentioned, you'll get some additional resources that will go into a little bit more detail on some of those details on the exact laws and the Title 7s and 6s, which I can never keep straight because I'm not a civil rights lawyer. And you'll also get some summaries on executive orders, things like that, right? So we're going to briefly touch on those. And then we're going to also talk about some of the other things that we're seeing and examples. And then really what I want to spend most of the time on, like Laura said, is what can you do? What can you do now? What can you do if you're a target? What can you do if you want to avoid being a target? And how to manage that. And I am really excited also, just like all of you, to hear about Carl's program and his new initiative for pro bono work, and to hear about how that can play out and what kind of opportunities that can offer for organizations. So I know that will be a good discussion. And then definitely Q&A, definitely send in your questions. I hope that we can get to a lot of them either through the discussion today or in a dedicated session toward the end. I'm going to try and leave a lot of time for that and use that as the way to impart as much information and examples, like I said, as possible. So let's dive into current threats. It's okay, we're 10 after, let's do it. Next slide. So I would say up until, I don't know, a year ago, the main thing that lawyers like me were worried about for organizations, and even in the past, right? This is not the first time that nonprofits have been under scrutiny for various reasons, right? People might remember the sort of Tea Party scandal when there was a lot of questions about whether nonprofits were being used for political purposes, or there have always been nonprofits used in not so savory ways, right? The whole current tax act that governs private foundations, right, that gave us this split in private foundations and public charities was theoretically at least a reaction to bad actors misusing charitable dollars. So this is not the first time that charities have been targeted, and nonprofits in general have been targeted. And private litigation has been where we started this mess, thinking through things like the Students for Fair admissions cases against Harvard and UNC a couple of years ago, and the decisions that came down through the Supreme Court. So we started there thinking about, okay, a nonprofit went after other nonprofits in that case, right? Students for Fair Admissions was itself a nonprofit, and it sued 2 universities. It then went on to sue additional nonprofits and for-profit actors, and those cases have just ballooned over time. Those are all mostly around diversity, equity, and inclusion practices, but they're spreading, right? And they're taking different shape. The Students for Fair Admissions cases, just to be very clear, those cases are about exactly what they say. They are about higher education admissions and what is legal in those contexts. The rest of the cases that have come after are meant to try to expand that context. The cases themselves did not automatically mean that DEI things and projects and programs were illegal in any sense in other contexts. And there was still lots of legality, as I'm going to say multiple times in this program. I've put a link here, and part of the handout that I sent around is going to be a list of current cases, but the Meltzer Center is actually doing a really great job of tracking litigation right now. It is really hard to give any kind of litigation update on all of the cases that are happening, both private litigation, and when I say private, I mean not including government parties, right? Not including somebody suing the government or the government bringing an action against a party, but just private organizations, meaning maybe nonprofits, maybe corporations, right? That kind of thing. It is really hard to keep track of all of that. It is constantly changing. There's constantly new, something settles, something moves forward, right? It's sort of a mix all the time. And it's happening all over the country in all different circuits, and not every case that gets moved forward or settles will affect you, right? This is a California-centric group, and we're in the Ninth Circuit, for example, and not every case that comes through the 11th Circuit, like the, I'm going to forget the name of it, the, what was it, Carl? The, in the 11th. Oh my God.
I'm not going to pass any tests today.
You're not going to pass any tests. It's the I want to say Founders First, but that was the other one. That was the later one. Anyway, there were a couple of cases that came through. They settled. And so, but they're in different circuits, right? So they don't automatically apply to us in our Ninth Circuit, for example, until something goes to the Supreme Court, and then we get a decision that is supposed to apply across the land. So helpful to keep track, particularly if you end up seeing that there is a case out there where the facts look very similar to your activities, right? So some of these are going to be about a program that had criteria in it where you had to be of a certain racial classification or a certain gender in order to get the benefit of the program. Some of them are going to be about employment-based claims, right? The Fearless Fund. Thank you, Matthew. That's the one I was thinking
exactly
of.
what I was about to say.
Too many F's. Fearless Fund, Founders First, not all the same. Thank you. Keep track of cases that look like your facts, okay? Don't try to keep track of everything. Let groups like the Meltzer Center do that for you. So private litigation is still something that we're thinking about all the time, but it is not something that you have to keep track of on a daily basis, I would say. Also, when there's private litigation and that case comes, through the court system, an outcome through a case, I just want to be really clear about this, an outcome through the court system is only going to apply to the parties in the case, right? especially at the lower levels through the court system. So two parties, there's a decision, whatever that decision is, it applies to those parties. It doesn't necessarily apply to everybody else until it goes to the Supreme Court and there is now a law of the land that says this is illegal or that is illegal. That's when organizations can consider that a fork in the road, and you have to comply with whatever those terms are, right? It doesn't mean that anything retroactive, anything in the past that you've done that doesn't comply with the new court ruling is at risk. Everything you did before then was probably okay. So you don't have to worry about retroactive stuff. And you certainly don't have to worry about, any kind of monetary penalties. Usually these kinds of cases are typically about changing practices. Most of the time, people are not looking for monetary damages, right? They can't usually show that they would have gotten that award had they been of a certain racial classification or something else. So it's really, a lot of these cases are being brought in order to get organizations to change their practices and in order to scare people, just to be quite frank. So I just want to make that clear that, that's how the legal system works in this country. You don't have to worry about what happens in someone else's case being directly applied to you or having financial penalties or things like that applied. That's not what the private litigation is about. So let's move. I want to talk more about government action. I think it's where most people, oh, sorry, go back to the previous slide. I want to talk more about the real government action, where that federal pressure is coming from these days. Right now, it's mostly coming from two general places, right? It's coming from either the executive branch through executive orders that are then leading to agency actions, right, in the executive branch. So an executive order, which you've probably all heard by now because the last 8 months now, have been full of them. Executive orders don't typically create law or change law for that matter. What they do is they are as if they're like a directive to the executive branch agencies from the president to say, do this stuff. Here's my instruction. Here's how I want you to implement the law that is already on the books. So it is instructive. It is meant to get the government agencies to do things, but they are supposed to be compliant with the other parts of the law. That's why you have seen lots of litigation challenging the executive orders, because they go outside the bounds of what existing law does, right? So that's part of why the executive orders are sort of pushing too far in many cases. And we're going to talk about a couple of those clear examples, particularly on DEI, and then also about the public service loan forgiveness program, which I want to mention because those are two things that have been sort of percolating most recently. The other way, and then so an executive order is issued or something like that, then there's an agency that sort of takes that instruction and says, okay, we've got to implement this instruction. How are we going to do that? We're going to do that through issuing reports. We're going to do that through changing our regulations, drafting new regulations, putting out new notices, having public comment periods for our rule changes, because there's a lot of administration that has to happen in order for those changes to happen. Or maybe they start investigations, right? The executive branch is there to enforce the law, theoretically, and so they can do various kinds of investigations, right? The Department of Justice can institute investigations through law enforcement or directly. They can, the IRS, we are all familiar, right, can do audits. And then there's even, other agencies that nonprofits typically don't deal with that often, but definitely have investigative power, right? The Securities and Exchange Commission, right? The list goes on about where investigations could come from. So that's sort of where that executive power and the pressure from the federal government can come from to look at and, build rules and additional investigation pressure for nonprofits. Then there's the congressional side. So private litigation, we kind of think of judicial, right? We're hitting all the big government branches now. So congressional actions are the other side of the thing that we're seeing right now from federal pressure. So Congressional actions can take a couple of forms also. One is that the House of Representatives absolutely has an investigative power associated with it. So through the committee structure of the House, there's sort of a system of being able to call individuals as witnesses to come and testify in front of Congress. And those calls for testimony and for information, people get letters, right, in the mail. They might get them over email. They might get them in various ways. They typically start with something kind of semi-threatening, but non-legal, right? So it's like here, we would really like you to send us this information. Sometimes it's just information. It's not like a come and testify. It's a send us this documentation. Then it might be come and testify. Then it might be, if you don't, we have the power of a subpoena to come and subpoena you to come and be in front of Congress. And if you violate that, then maybe we can, you'd be in contempt of a congressional hearing. And there could be consequences for that. That whole process is, I would say, I am not an expert on this, but it is quite political, as you might imagine, right? It is actually a very political tool as opposed to a purely legal tool. Because what does Congress have the power to do? It has the power to investigate and call you to, come and give testimony and give information and sort of bring light to whatever information they think is important. And then it has the power to legislate. So the theory behind being able to investigate is then it should be able to create law that addresses whatever it has learned, right? Right now, it's not doing a whole lot of the legislating. It's doing a whole lot of the investigating. And even that is sort of questionable. It's doing a lot of puffery around the investigating, and it's sending out a lot of letters, but there's not a lot happening behind it. So it was new to me when all of this started recently to learn that the kind of lawyer that you would need to talk to in some kind of congressional investigation is probably a white-collar defense lawyer. Now, I think of a white-collar defense lawyer as like somebody who represents Enron. Like, that's my generation. That's what I think of for that. But really what it is it's somebody who can think through the political ramifications, the legal ramifications, and the defense tactics for any kind of sort of civil, criminal, federal bucket of risk. and those are the folks right now that are doing a lot of help. For example, some of our really big private foundation clients that are doing sort of cutting edge, equity work or things like that, folks who are really concerned about being targets of the administration, or who are in fact already targets of the administration, in news articles and things like that you've probably seen. Having those folks on board is incredibly important. Folks like me and Carl, we are experts on how to maintain your tax exempt status and how to, manage your assets within the bounds of being a nonprofit and a tax exempt organization. We are not experts on how to respond to a congressional inquiry. So one tactic that we're going to talk about as an action to take is be ready to have your team of folks available to you. All of that is going to be based on your risk profile, though, right? So it's not like everybody needs to go out and find a white-collar lawyer and put them on retainer. But knowing who you need is sort of part of the resource list, right, that I want people to leave here with, which is why I'm spending a little time talking about who is it that you'd look for if you needed someone. The other things on this list, so False Claims Act, illegality doctrine, terrorist designations, those are things that are specific things that have come up in the last 8 months that organizations have not thought a lot about, nonprofits have not thought a lot about, but that have been on the table a lot. So I think they're worth mentioning, and then I'll go back to DOJ best practices and the PSLF program. So the False Claims Act is important to understand, and it's coming up a lot for organizations that have had federal funding revoked, and then maybe even offered back or had their federal grant terms amended by including a new certification provision that requires an organization to say, yes, I'm getting this money, but no, I don't do any other programs. We don't have any programs that that carry out illegal, quote unquote, illegal discrimination or anti-discrimination, programs. I'm complying with all anti-discrimination law. So the False Claims Act is set up to make sure, theoretically, what I love about this time period is that when you explain something sort of on its face, everything sounds great. False Claims Act is created so that the government doesn't get defrauded. That's a good thing, right? We don't want the government to get defrauded, because if it does, it means that taxpayer money is being used for a fraudulent purpose, right? And we want the government to have a way to, get compensated for that. In this case, the False Claims Act could be used to say, hey, you organization, you signed this certification that said you weren't doing anything illegal. But lo and behold, you have a program where you have an internship, and that internship is reserved for people of a certain ethnic group. And this government believes that that runs afoul of current, anti-discrimination law. So we think that you signed this under penalty of perjury, fraudulently, knowing that you had this program and that it was discriminatory. And so we're going to say that you violated the False Claims Act and go after you to get all that money back and impose penalties and other things. False Claims Act is a little bit scary because it has some bad penalties associated with it. What I want to tell people about the False Claims Act, really importantly, is that it is a very, very high standard for the government to meet. One, very, very high. So it means that they would have to prove that you knowingly defrauded the government, on purpose. It was a whole scheme. You signed it knowing that everything was wrong and that you wanted the money and used it anyway, right? So very high standard for the government to prove. Second, you can fight about it because everything that is part of that example I just gave, where the government says, oh, you defrauded the government because you were doing a program that we think was discriminatory because you were, limiting one part of your program to a certain ethnic group. The law hasn't changed. The law hasn't changed. There are still absolutely ways for organizations to run that internship program. There are absolutely ways for you to have scholarship programs that, target a specific ethnic group or racial group or gender or whatever it might be. So DEI programs in general are not illegal under current law. There is still plenty of case law, statutory law, all kinds of things out there that show that these are still legal, and just declaring it so by the federal government doesn't make it true. So there are still ways to think about the False Claims Act. So I just wanted to put that out there, that there are ways to combat that. The illegality doctrine is something that in the regular course of business, many, many organizations do not think about. It's underlying the concept of 501c3 and charitability. So most of the organizations on this call, I'm going to venture to guess, are 501c3s. So you applied to the IRS to say, hey, we think we meet the definition of being organized and operated for charitable purposes. And the IRS issued you a determination letter and said, yep, we agree based on the information you provided to us. Here's your determination. You are now tax exempt, and donors can give money to you and they can take a deduction based on that determination. The illegality doctrine says that it is not possible. It is an oxymoron for an organization to be charitable, organized and operated for a charitable purpose, and to have an illegal purpose at the same time. There's a slight nuance to that also that you might hear if you're being really nerdy and diving into, legal articles about this. So you might hear about the illegality doctrine, and you might also hear about a substantial, about a fundamental public policy of the government. So being outside of fundamental public policy. So the idea is that the government has granted this opportunity to be tax exempt, it does not make sense for the government to offer a tax exemption to organizations that are contravening what the government believes is in the best interest of the country, right? It does not make sense for the government to say, yes, and a terrorist organization that is also providing food aid to a local population can still be tax exempt, right? Because the terrorism would sort of outweigh the food aid that they're giving. So it's in contravention of public policy. Other illegality things might include literally committing crimes, right? So you can imagine an organization that starts out by thinking that they're doing civil protests in a totally respectful way within the boundaries of the law, and then it sort of goes, I feel like I'm giving weird references today, monkey wrench gang, right? And like starts, destructing, property, going into work sites to dismantle tractors so that they can't, plow land that should be preserved, things like that, right? Going further into vandalism, actual committing crimes, right? And if it's a purpose of the organization to do that and encourage people to do that, they organize volunteer trips, they may give people the tools to make that happen, right? That it would be considered part of an illegal purpose, and that organization should not be considered tax exempt. So that's something that is sometimes new to organizations these days. They just haven't had to think about that because they're just out there doing their charitable purpose. Why they're having to think about it now is that there are certain buckets of activity that the current government would like to call illegal or push into that bucket of illegal activity because it serves their current purpose. So things like supporting immigrants, right, with either legal services or even food aid, sort of basic necessities. Definitely protests, right? Other exercises of First Amendment and free speech. What are the other things? They have a whole thing about terrorism, right? They're really on top of that right now because of all the support for Israel. So that's an issue right now. And then I think there's one more in the PSLF topic that's coming up these days. But so they're trying to sort of push more into that bucket, again, sort of by declaring it so, right? That these things are illegal. Carl, did you have something?
Oh no, I mean, the only thing I was just curious to ask you this question because although these are definitely in the context of the illegality doctrine, which I think is like the thing that's squarely in me and Shirley's area, and up until 6 months ago, I really only talked about with clients in the context of like psychedelic medicine and things like that, where that's where the IRS has applied it recently.
Yeah.
I have, in case anyone's wondering, like I have yet to see any IRS use case of the illegality doctrine. It is a thing. Like the prospect of them using it is out there and floating out there in the ether, but I at least have not seen any use of it. I don't know if you have, Shirley, or if there's whispers
No.
of it or anything like that.
I haven't, and when I have talked to people who are currently at the IRS, career exempt organizations, IRS people, who they say, if somebody wants me to apply the illegality doctrine to an immigrant serving organization, I'm out. Like that is wrong. I'm not doing it. So I agree, Carl. I haven't seen it come up. There's been no notice issued. There's been nothing like that. There's just been these sort of pop-ups around it, like the public service loan forgiveness notices that are trying to sort of bring it all in and really, wrangle up everyone's hackles, to get everybody scared a little bit. I'm not going to spend much time talking about terrorist designations. There is already law that says if an organization is designated as a terrorist organization through other channels not related to being a tax exempt organization at all, but just there is a designation out there, then that organization will lose their tax exempt status. that discussion was resurfaced actually partly in the first Trump administration around Black Lives Matter movement organizations, around protests after George Floyd's death. So there were there was some discussion then saying, oh, these groups are terrorists and they should be designated as such, and they should lose their tax exemptions. It resurfaced because there was a new proposal, HR 9495, that came up early in Congress, and then that died largely because of nonprofit lobbying efforts, actually. And then it came up again in a new form in the OBBA. So, and also went away. So good job, everyone, for now, for having that go away. What those proposals would do is basically expand it and make it, easier for the Treasury Secretary to designate organizations as terrorist organizations, and even create maybe this new category of terrorist supporting organizations. So it kind of daisy chaining up the funding scheme to say, well, even if you're not doing terrorist activities, you funded them in some way, and now you're on the hook. So so keep an eye out for that. We don't think that is dead as a proposal, but it's a little bit scary, and hopefully we'll keep shutting it down through legislative means. So let's talk a little bit about the latest from the government on DEI. I put in quote best practices. So the Department of Justice and the Department of Education, Pam Bondi the Attorney General decided to put out this, I don't know, 11 pages or so, 9 pages or so, on what the government thinks is best practice when it comes to DEI programs. What it does is starts off by saying, here's what we think that organizations that are receiving federal funds should do or not do with regard to DEI activities. And then immediately in the next sentence says, but really everyone should be following this, not just federal recipients of grant funding. And then it proceeds to sort of list out in a few buckets what it considers to be maybe not okay and maybe okay. It really is trying to sort of get at the things that people like maybe Carl and I have been talking with organizations about, to say, hey, if you don't feel, if you have, based on your risk tolerance, you don't feel comfortable only talking about race anymore because you think that might target you a little bit, great, talk about other things, right? Talk about geography, talk about education, talk about socioeconomic class. So for example, one of the best practices says, no, you can't talk about proxies anymore. If you're talking about geography, or first to graduate from high school, but really it's just a proxy for race, that's not okay. And it just goes on and on like that, sort of talking about, this is not okay, that's not okay. And it's worth a read. The reason I think it's worth a read is because it will give you insight into what the administration thinks about this stuff. Again, what it doesn't do is change the law, and it doesn't need to change what you do on a day-to-day basis. It might be more important for organizations that are trying to comply with, the certification requirements for their grant funding, and who don't want to get sued or have to sue in order to keep it. But that's sort of my take on it. The other thing I heard just from other, big practitioners and from the sort of DC community was, it was like, nah, nobody cares. And I was like, wow, nobody cares at all. But I do think it's worth reading, just so that you get an insight into how they're thinking about things. What do you think, Carl?
Yeah,
Did
no,
you
I
read
mean,
it?
like all of you, I was not waiting for Pam Bondi's input on best practices for DEI, and not a reliable source for me. But like I said, Shirley's saying, it is relevant. I do think it's important to read it with an understanding that it is an assertion of the Department of Justice. This is interpretation of how the Civil Rights Act should be interpreted, and other related laws should be interpreted. It is not a statement of how it is currently interpreted, or what
That's
the law
right.
is. I think if you were to reduce their however many pages of let's say analysis into like a single sentence or two, the position of the administration is effectively anything other than color blindness is racial discrimination.
Yeah.
And I think people doing DEI work know that that is not an accurate, thoughtful, correct statement, and it is also the case that that is not what the law says currently. That
That's right.
anything other than color blindness is a violation of these things. There are, it is not that to say it is impossible to be engaged in racial discrimination with the right intentions, but it is still too narrow of a view that the ones that they take, at least compared with what the law says, right? And
Yeah.
so you knew before the DOJ published this guidance that that's how they felt about it. In fact, they probably feel a lot of other things that aren't in that guidance.
Yeah.
Now you know that too, and you can take that into account in terms of your risk management. But we do want to be careful to not give those the statements of force of law, right? I think that's
Yeah.
always, and with all this stuff, that's what Shirley and I are struggling to do, is make sure y'all are informed about how they are thinking about it. If you want to speak their language, like what the way to manage the risk is. But yeah, anyway, that's
Yeah. Yeah. Okay, so let's start getting to what folks can do about it. And definitely I want to start bringing in Carl to talk about his initiative. So in the next slide, I'm going to talk high level very quickly. And once we get to keep professionals on standby, that's where, Carl, I'd love for you to talk about the DEI project. So what can you do, right? There's all this stuff swirling around. If we can answer some more questions about the public service loan forgiveness. Sorry, I didn't spend too much time on that. What can you do? Right? If you are operating programs that you think are going to be targeted by the administration in some way or by private parties in litigation, here are just some basic things that every organization should be doing right now. You should be doing a compliance audit. Are we up to date on our filings? Are we compliant with all of the state regulators? California, that's a hefty task, right? You've got a Secretary of State, you've got a franchise tax board, you've got a California Attorney General, you've got local regulators sometimes, right? That is a hefty task. Make sure that you are in compliance status with all the agencies. Don't let those footfalls be a problem for you, right? Have you filed all your tax returns with the IRS for the last 3 years? You do not want to be auto revoked right now. And that's just an opportunity for, detractors, right? Don't let them have that. Make sure that you have the insurance that you want. Go talk to Cole Kinney at Cal Nonprofits, right? Go talk to insurance brokers to say, hey, do we have what we need to make sure that we are covered? Do we have the cybersecurity insurance that we think we need? Because that's another avenue for attack right now. If organizations are, worried about their systems being, infiltrated, let's get to that. So do a compliance audit. That can be done internally, right? You don't have to have a lawyer to do that. I'm sure that there are resources in, Cal Nonprofits and other kinds of groups to be able to, and your associations, to be able to figure out, okay, where's my checklist? What are the things that I can start on today to make sure that we are in as good a shape as possible? That's also one of the resources that I've provided. We call it hardening the target. Like, let's make you not the lowest hanging fruit for somebody, including government, to come after. Have a plan for public and government communications. Who's your spokesperson? What are your talking points? Do that in advance, right? Do that thinking and planning in advance so that you are not rushed and pressured in the moment, in addition to just, the adrenaline that will kick in as soon as there is an inquiry, right? So have a plan. Other procedures in place so that staff know what to do, right? Don't just keep that at the executive level. Let everyone know what happens. If I had a client that contacted me and they said, oh my God, we have a WeWork space in Boston. Somebody showed up and said that they had some papers to serve on one of our people there. What? No, nobody was there. And we think they're going to come back. What do we do? Right? That's the kind of thing that, just know what to do. Think of it in advance. Tell everybody that if somebody comes to serve you papers, you accept the papers, you don't say anything, you be polite, and you turn it over to XYZ people, right? That's it. You don't run away, you don't try to avoid it, right? Just know what to do in the various scenarios where things might come up. And then, like I mentioned before, keep people on standby. Know who you think you might need. That probably includes, yes, a lawyer, maybe more depending on your circumstances, more than one lawyer. It probably includes some kind of communications help, right? A PR crisis communications firm of some kind. Just knowing who's in the field, even if you don't contact them until you need them, having a couple ready to go that you can contact instead of asking around for referrals when you need it, that will be really important too. And then there could be others, right? Thinking through, knowing who your insurance folks are, right? Not having to wade through bureaucracy to find somebody. Who else, Carl, would you include in that sort of list of folks that you want close at hand?
Yeah, that's a good question. Yeah, crisis communications, I think is a good thing to have just in general. If you don't already have a lawyer, that's your first contact point. Who do you talk to? Just to,
Mhm.
um, but I think fundamentally the things that you listed out are the things I'm kind of calling out that should be
Yeah.
part of your response plan.
Yeah. Maybe, it's helpful as part of that list of lawyers that you keep to think about and have a list of current resources for pro bono support, of course. So there are a couple of programs that do that. And I would love for you, Carl, to spend the time, talking about the project that you've started.
Yeah, no, thanks, Shirley, and thanks for all that, which is really helpful, really, and completely agree with everything. I think we're all audience and speakers trying to do our best to keep up with a lot of stuff. I guess that's sort of, I mean, so about, we started the Defending Equity Initiative, which is a new nonprofit public, pro bono provider for 501(c)(3)s. If you're a C4, still feel free to reach out. We'll figure it out. But 501, why did I start it? Because I spent the first 6 months of the year feeling just kind of completely useless. Still feel mostly useless, to be honest with you. But I at least like I think me and Shirley struggle with this thing of like, we're tax exempt lawyers. I know how to defend your tax exemption if someone comes after that. And there was a lot of discussion around that. And I've always felt of two minds about discussions, like this, where on the one hand, I don't think that is the line of attack that is or will happen. I don't think I haven't seen any evidence of it. I don't see why they would when it would involve funding the IRS, which is basically anathema to a Republican, and would be a really high bar. And even more importantly, I don't see why they would when they have gotten organizations with millions or billions of dollars to cower and change the things they do just by threatening that it might happen, right?
Mhm.
And so that's very cheap. A tweet or a Truth Social or whatever it's called is very cheap. And IRS audit enforcement would be likely to, but yes, this is the kind of thing to defend. On the other hand, the fear is out there and it has accumulated, and I do think that like my response is usually like if that crazy thing happened, I think there's lots of people that would want to get involved and do this pro bono. And so one reason we created the Defending Equity Initiative was just to like start building a network and to be a place to provide the pro bono service regardless of where someone's at, that they could like, hey, I want to help out with an organization that's facing some kind of target. I have a set of useful skills. Can I provide it to your organization? Maybe my employer wouldn't want me to take this on as part of their organization. We'll have insurance and we'll do that. And so that's thing one. And then to find people with more useful skills than I have as a mere tax lawyer, like immigration, lawyers, criminal defense lawyers, to answer the great question that I saw someone ask that I've had a number of organizations ask me about, which is where is the line for aiding and abetting? And the takeaway, my main takeaway being, I I think that when we all look back on this period of history, no one is going to look back at the harm to the nonprofit sector as a sector. I mean, it's going to be on the list, but it might be number 50 or 100 on the list of harm that happened. The real harm that we're all worried about is the harm to the causes we serve. And I felt, and maybe feel less now than I did at the beginning of the year, but for the first few months of the year, I was really concerned about like everyone is we are internalizing this fear, we're focusing on this instead of the things, and having organizations ask me to make changes to the kind of stuff they do or to their bylaws or policies that are kind of shocking to me because like Shirley and I, have alluded to, like the law actually hasn't changed here, and um, you know, a lot of the rulings, that the materials will reference will talk about what's illegal DEI is what you can't do, which of course begs the question of what is illegal DI. And my answer would be, well, it was legal yesterday. Like it was legal 6 months ago. and such that I think finding through the goal, I think, in addition to just sort of being a troll, like and applying for exempt status and seeing if trying to prove that yes, you can still get it. I still tell progressive organizations to apply and do exactly what you were doing before, and I think that the same is true for this nonprofit we formed. Um, application pending, knock on wood, etc. But also, I think just sort of like, can we cross these issues off the list so we can focus on the other stuff and really just build a network? And, in general, there's lots of other nonprofits doing a lot of great work on this. And my main takeaway and ask would be two things. The website's got two forms on it. One form is for people who have some set of skills that want to volunteer it. There's no commitment. If you have a set of skills in a particular state or a particular place, or I know how to do exactly one thing, like I know how to do, like great, just fill in the form. You're not committed, but maybe we could reach out to you if like, hey, your thing came up from some organization that was under attack. And the other is a form for organizations as well. It's like, hey, I think I have some kind of live thread or uniquely am facing that. You can just put your information there. The minimum we can sort of talk to you, and the goal would be to provide pro bono services. For the handful of done so far, we come up with a statement of work. We say, okay, here's what we're going to do. Here's the things we can give pro bono, and when we're done, here's a bunch of great other firms that can take this if you need more help. So yeah, that's the gist of it. Those are the asks. If you're worried about your organization, fill in the form for your organization. If you have skills, it doesn't have to be legal skills. Sometimes like the things that Shirley was listing out, it's not legal skills. It's yeah, good crisis communication help, grant writing help, like and I'll toss in. So in terms of what I am thinking of as threats, I'm tend to interpret it pretty broadly. I mean, in terms of threats we're trying to help respond to. The federal government is a threat, and if I would, in general, I think as a exempt organization, if you don't have federal grants and contracts, I don't think you have as much to worry about as most people might think you do. If you do have federal grants and contracts, I think you have a lot more to worry about than you do because you have something to lose.
That's true.
Taking away your tax exemption isn't going to do much for the federal government because most charities wouldn't pay that much taxes anyway. It's not an actual thing of value other than to scare you. But losing a federal grant or contract is devastating, as many of your organizations probably know already. State attorney generals, it's not something I've seen a ton of yet, but red state attorney generals could use the broad power that attorney generals have over charities. So knowing people in more states, I don't think we have to worry about our attorney general being in that category, but we do. But there are organizations in multiple states, and if you're in that and you have concerns, that would be a place. The other thing, and this might be controversial depending on who's in the audience, but I would say the biggest tangible harm I've seen in the new administration is funders pulling back. And so if you have a funder that is getting nervy about things and doing things like telling you, hey, you need to have your legal counsel vetted this and approve this, or you need to cross these words out or do these things, happy to kind of counsel, and we've pushed back successfully on both sides
Add
of the
this new
house.
provision to your grant agreement that looks a lot like the certification the federal
Yeah.
government's asking you to, yeah.
Yeah, help tell your funders to have a little backbone. Tell them the law hasn't changed, and tell them, you didn't think this was illegal a year ago, so why do you think it's illegal now, right?
Yeah.
And I think those are the things of value because, like I said, I think that a lot of the harm, I don't want, it's not self-inflicted as in it's not reasonable to be afraid. I understand how we've all gotten to this place, but it is still a lot of self-inflicted harm, people changing their mission statements and having kind of an employee revolt in response. Like,
Yeah.
there's nothing you can do. And so like, yeah, the premise of the organization is like, we don't need to change, they need to change. And so let's try to hold the line together. Let's get a group of people who feel that way and would want to volunteer support. And yeah, just try to hold the line that these things that were valuable and Fortune 500 companies were all saying they stood behind 5 years ago are still just as valuable and legal now. So that's
Yeah.
that's kind of the push I would be making.
Yeah, great. Thanks, Carl. I think it's really exciting, and I hope people take advantage of it and get in touch with you and the new organization. I think fundamentally, what allows us to give this kind of advice to clients when we are in a specific client relationship is that we can talk with an organization to say, okay, what is your risk, right? Truly, your actual risk, and So what are the sources of that risk, and what is your tolerance for that risk, right? That's a lot of the initial conversations that Carl and his team are going to have with organizations. It's absolutely some of the first stuff that we do at my firm. This slide shows you a couple of examples of some factors that we came up with. You could come up with zillions. We happened to come up with, I don't know, like 14 or something. And these are some examples. So the first one listed on here, right? Do you require an individual applicant or an organizational applicant's leadership to be of a specific race, or is the applicant's race one consideration among many in the selection process? A lot of these questions are geared toward DEI issues, but you could easily apply these to other scenarios, right? And think about, okay, on a spectrum, where is our organization? Notice that we specifically didn't choose like red, like stop sign color, right? It's orange. Okay, maybe there's some risk from a PR perspective, from a private litigation perspective, from the government looking at us and sending us a letter perspective. Is there a risk that we are literally doing something illegal? No, right? Because that is still legal for a nonprofit organization to do. All the way over to, no, we don't do that. And so it's totally open to anyone. And there's probably no risk from that factor, right? Going through a set of factors like this is a little bit systematized. Sometimes it's just gut feeling from a lot of people, right? Like, no, we have a lot of risk because our name, our founder is on the, list of people that Donald Trump hates, right? That is an issue for some people. Going through factors, really making it as concrete as possible, right? Getting it out of that gut feeling space where there's just a lot of fear and angst can be really helpful for your board, for your leadership, for your staff even, right? I've done this actually for a couple of organizations where at first they say, hey, can you just come talk to our board for a little bit? And they're like, yeah, sure, no problem. I'll come talk to the board. And then they go, wow, actually, we need you to talk to our staff because they're the ones who are dealing with this every day, right? The board is just one piece of this, but really it's our staff who are trying to figure out what to do on a day-to-day basis and make decisions. So thinking about these kinds of factors, just doing a risk assessment, right? Where are the real factors of risk and how much risk are we willing to take on? And that might be a sense of the resources you have available to you, right? The government funding, right? Is that 50% of your funding? Is it something else? So I've actually included this risk assessment, the full risk assessment, with a big discussion of all the factors. We developed this in partnership with Black Freedom Fund and Lawyers Committee for Civil Rights. And we, were really only using it in client work until recently, paid client work until recently. But we have decided to start sending it out to groups like this. So I'm so glad that you all are here and can get this now. So, take advantage of it, and hopefully it'll be a good tool for folks to use. Last slide in the last minute before we maybe shift to questions and answers is I just want to say, do more stuff, right? You are a charity right now. Think of new tools, right? New tools for you. None of these are brand new, right? Lobbying and advocacy, if you haven't been doing it yet, go talk to your grantmaker associations, go talk to League of California Community Foundations, learn how to do it. You can do it. It is effective. Go do it. Redirect resources, right? You have a big program that you did specific fundraising for and donors gave specifically to that project. Maybe it's not core mission anymore and you need to go get those donors to release that restriction. Consider it, right? It's not something we do on a regular basis. Consider it. Other tools, maybe you actually need a whole new C4, right? Maybe you need some other tools in your tool chest now. Think about those and think about going on offense, right? Risk assessment is really more about defense, in my opinion. Think about offense as much as you can. So that's where I'll leave it for now.
Thank you, Shirley. Thank you, Carl. Lots coming through in the Q&A. I'm going to do my best to batch them thematically a little bit and also kind of go back into the order I think that they came in terms of who is talking, but you guys have been a great team so far, so feel free to chime in as we go. There were a few questions along the lines of what types of organizations are implicated or targeted by, I think these questions came in around the time you were talking about the newer executive orders, but maybe sort of the broad threats that you walk through. One example given is a nonprofit neighborhood association that is helping maybe undocumented neighbors be escorted to appointments, for example. Are they at risk as a nonprofit? I'm assuming a registered nonprofit in this case, of being targeted for harboring or obstructing something that the administration considers unlawful. There's also a question about whether these new orders or regulations, when they are regulations, apply to organizations that receive Medicaid funding, for example. So not necessarily like a single grant or
Government grant,
contract,
yeah.
but who steward and administer federal funding for programs like healthcare.
You want to start, Carl?
I'll take my pass at the immigration one, which is, as I alluded to earlier, is not as helpful as I'd like it to be. But I can say that I've had clients reach out to this on this. I've done my best to reach out to immigration lawyers, and I don't, here's the answer I would have so far based on who I've talked to. That would seem to me to be a wildly aggressive, unfounded interpretation of the definition of abetting law, abetting violations of immigration law. I forget the exact code section. And is it a possibility that they will use that statute anyway, in spite of it? It's possible, right? I do. And then the question is, well, okay, well, now what, right? Sometimes reflecting on my life over the last 6 months, and probably before that, there's just limits to how useful a legal answer is to a problem. Like, I would be very surprised if the legal answer to that question is yes, you're at real meaningful legal risk in a world where the correct answer matters. But I often think about what would happen if someone, I don't know. I mean, the administration operates in many ways like kind of like organized crime, right? Intimidation, extortion, right? And I often think about like what would happen if someone called me and so they said, okay, well, the mafia's here, they're about to break my legs. What can I do? I'm like, well, that's illegal. They can't, that's not a very helpful response when your lawyer tells you it's illegal for someone to harm you illegally. Like, it doesn't actually do you a lot of good. So, it's a call that at the end of the day, your organization kind of has to make and balance what, to me, easy for me to say, seems like a pretty remote and hypothetical risk and something that they would be very hard to prove and something that they should lose, etc. And you got to weigh that risk against the very real risk of people who need your help not getting it, right?
Yeah.
So,
yeah.
and that's the call we all got to make. And I think, again, that's kind of why I think the network, whether it's our network or other people's net, like we're all just trying to like get each other's names. So like if that happened, there's someone you could call to say, look, I don't, I'm trying to gather a list of criminal defense lawyers in all 50 states that would want to help there,
Yeah. I also think that's a really good example where like more and more I'm starting to think about privacy, right? And sort of like physical security concerns for individuals, for leadership of organizations. Nonprofits and tax exempt organizations have given up some privacy rights in exchange for their tax exemption and their nonprofit status in a lot of ways, right? Your 990s are public information. There's a lot of information about people available. So this is an area where I would say, nonprofit, neighborhood association. Do you need to be tax exempt? Probably not. Could you form an unincorporated association that basically has no income, is totally volunteer run, has no tax base, and never file anything with a state agency? You know what I mean? Like things like that, where it's like, gosh, in certain scenarios, it may make sense to like stay off the grid. So I think that there are opportunities like that for even for more formalized organizations to start thinking a little bit more about how to protect information, to protect people, and to make sure that if they are going to do the thing that could be a little risky, where there is no, beneficial legal answer, to at least be as protective as possible.
Thank you both for
the Medicaid question.
crowdsourcing that.
Sorry about that. The Medicaid question, I do think there is a whole body of law about Medicaid fraud, and like False Claims Act sort of is a baby sister to that, I think. So I do think that there would be a huge bucket of like my guess is that using any kind of Medicaid funds for gender affirming care for kids is totally off the table at this point, things like that. So yeah, I think that if you're in that space and receiving a lot of Medicaid grant funding, that it's definitely something you're going to want to talk to your healthcare counsel about.
Yeah, thank you for that important extra clarification, Shirley. A couple questions here. Shirley had mentioned a bit ago about, different sort of angles of legal expertise applying for different scenarios, but depending on how you've determined your risks and vulnerabilities in an assessment. There's a question, if you could kind of restate, what kind of lawyers should you be thinking about maybe needing, depending on those big buckets of risk we identified? And then similar in terms of what resources to sort of pre-position. Is it an HR question or a legal question to start to develop a policy for what to do if ICE approaches your staff and enters your office, shows up at an event you're hosting, et cetera? So what kinds of people should you be thinking of identifying in
Yeah.
advance?
Oh,
As you said,
gosh.
not maybe on retainer, but kind of having in your back pocket.
Yeah. So I think you just mentioned like 3 or 4 right there, right? So definitely immigration lawyer, right? You may not be providing immigration legal services, right, as an organization, but because you are working so closely with immigrants in an organization setting, absolutely have access to an immigration lawyer available to you. Employment lawyers, absolutely, right? A ton of these civil rights laws that the federal government is trying to, reinterpret, actually a lot of the case law is in employment context, which makes a lot of sense, right? Employment is such an important area. We want everyone to have equal access to employment in this country. So yes, there's a ton of case law about that. But it sometimes bleeds over into other areas. It also will help you as an organization to make sure that your policies for how you treat employees, right, how you protect your employees, if, both from like if ICE came to your place of employment, how would you protect employees? You're an employer, right? How would you protect employees? What would your reactions be in that scenario? And if you had, clients or beneficiaries, other folks for your programs who might be there, on site, what would you do? So I think absolutely employment lawyers would be really helpful for that, right? Having employee handbooks, knowing what would make sense in those scenarios. Those two would probably work together, right? The immigration lawyer and the employment lawyer. Have you seen that, Carl?
No, yeah. I mean, I agree with all that. Immigration that they can work together. I
Mhm.
would also, I mean, the only thing I would layer on is like maybe don't overthink it so much. I think
Yeah.
start with a lawyer. You know what I
Yeah.
mean? And then
Any.
because I think like when lawyers have value, which is, not always, but when they do, when they're useful, they are good at like demystifying a situation that seems complicated. So yeah, in a perfect world, and you may need an immigration lawyer, you may need an employment lawyer, you may need a criminal defense lawyer, you may need a false claims act lawyer. I don't even know what kind of lawyer that is. But
Yeah.
and but the starting point would be like, hey, have a conversation with someone that could say, okay, like this is what you're dealing with. And I, lawyer who know a little bit more about this, if not much more, here's who I would start with. Like
Yeah.
knowing that you could have that. So like if you don't already have a relationship with whether it's a pro bono organization or a law firm or a lawyer, or just someone to like can help me start figuring out where to go, because it's really hard to predict to know exactly what your threat is going to be. So that's my only, in addition to everything Shirley said, that's my only general advice is to not try to solve everything before it happens.
Yeah. Yeah.
Great, thanks for that. We have a question that I think might be fairly universal, which is indicating there's some interest in maybe follow-up conversations with you both, either both of you, or inviting folks like you, voices like you, into other spaces of nonprofits. We had a question from a coalition that works on ITINs. I'll leave it
Mm.
to you to share whatever contact info in the chat for folks that we can also include in a follow-up, your firm, of course, and also your contact info if you'd like, so folks know how to get in touch with you. There are also a lot of questions that I don't know that we'll tackle in the remaining 5 minutes, but great to see some links already coming through. Thanks, Carl. There is a specific policy question here. Can you share any information on the MOU that HUD has with Homeland Security? Is
Mm.
that an area that you would chime in on or refer someone to another resource?
Who gets to say no
That one's
first,
not.
me or Shirley? I'm not sure I could.
Yeah. No, I don't know. If it's if it's immigration related, is that the idea?
I
I
believe
don't
so.
know. Yeah.
Yeah.
No, I don't
Food
know
for
about
thought.
the specifics. Yeah.
Thanks
Thanks
for that
for
question.
bringing
We
it up
will
though.
feel free to also crowdsource that among, I'm sure, the many the many
Yeah.
experts operationally in the chat here. I will move on to Carl. You had touched on dynamics with funders, with philanthropy, not just government funders. But what would you recommend if your organization has been called out? I don't know if that means by funders, by the public, by the government for DEI training activities, which were not just encouraged, but actually required for funding in the first place just a year ago. Is there kind of a short narrative
Yeah.
response that you would offer?
Yeah, no, if it were me, it would probably be something along the lines of, we're thoughtful about all our programs, including the one you mentioned, and we believe we're in full compliance with the law. And if you want to be petty like I would be, yeah, including the one that requires us to do exactly that, if you want to be. But I would just say, less is more. The people that are trying to make you feel like you're doing something wrong. Some of them do have real power. If you're on the other end of a federal contract or you're getting federal funds, or you're doing something like federally regulated in a unique way. But a lot of them are just angry people with social media or whatever, and I would just treat them as such.
Yeah. I also have found that even clients that are, used to being in touch with me for these kinds of issues where they have gotten some pushback from funders or been asked to sign new grant terms or things like that, they've come to us and said, hey, this is what they're asking us to do. Like, do we really have to do this? And sometimes a client, like the organization's first inclination is to have us as lawyers contact the funder. And I have actually found it much more successful to have the organization go back to the funder. Bringing in a lawyer really escalates everything, even if your funder has in-house counsel, quite honestly. The more you can keep it at like the program officer and the grant administrator level, right? And sort of keep it there and keep those discussions open and happening, that's usually where it gets resolved the fastest with the least amount of friction. So certainly consult with your lawyer when you need to, just to make sure that you're on the right track, or, get some ideas for language or things like that. But but it's usually, beneficial to keep it between clients.
I totally agree. My only addition is like my flow chart is there a lawyer involved? Then you don't need to get us involved. If so, might be beneficial. Let's talk about it. Because I have it when, yeah, with if bringing a lawyer on is a guarantee to get their lawyer on. So like however conservative you
Yeah,
think the program officer was going to be, their lawyer is
the
probably more
lawyer's going to be more
conservative.
so.
Conservative in like the lowercase c way. Um, and so, but yeah, but when I have had some luck when the funder's lawyer sees that they're getting legal counsel, they're somewhat relieved that like, okay, well maybe this is less our concern, but it differs.
Great, thank you. We aren't getting to all of them, but I will close with one that I think probably resonates with a lot of attendees whose immediate next step will be to either conduct or maybe revisit a risk assessment for their organization. The question is, do you recommend that that is better done internally by the organization, staff, board, et cetera, or is it best to have an external kind of thought partner, a consultant to help conduct that, or does that depend?
I mean, the lawyer answer is it depends. The only the real lawyer answer I'll give you is, if you think that there is very high risk, the benefit of having a lawyer in the room with you is that potentially then that risk assessment is privileged, right? And can't be used against you later. Because usually that risk assessment is going to involve document production and, written analysis and a bunch of things, right? So do you want a bunch of documents laying around that on discovery and litigation or a congressional investigation or a DOJ investigation or an IRS investigation leads to, oh yeah, we totally knew we were doing risky stuff. You know what I mean? So that's really in kind of extreme cases. I don't think it has to happen that way all the time. I don't know if you agree with that, Carl.
No, that's way better than the answer I was gonna give.
Okay.
Like, and yeah, like in a perfect world, you get all the help you need and can support it. And I think Shirley's giving a really good reason for like, if you're gonna start producing documents that you would hate to have the government see, like work with a lawyer. If you're doing something softer, gentler, more just kind of like ticking through the boxes or having our own internal conversation, maybe start with using the kind of guide Shirley shared as like a a meeting, something to discuss at a meeting, at your board meeting, an executive session or otherwise, and just kind of like do that first and then decide, oh, we've
Do we
unearthed
need
enough
more?
stuff, we need a lawyer, or you know what, actually, all things considered, we can allocate our money elsewhere.
Great. Thank you both for that nuance and candor, which we've appreciated throughout your presentations today. I'm really seeing that reflected in the comments in the chat as well. As a reminder to everyone, as we move toward a close, this session will be shared back out with registrants along with slides, supplemental materials, some of the links that you've seen come through the chat today. Another round of very warm thanks to Shirley and Carl, our expert speakers today. Please stay tuned for another installment of the California Policy Forum later this year. And also remember that we'd love to hear your ideas for topics that you'd like to see highlighted in this series. For now, I want to leave you with a call to action that this is a moment of shifting sands, as you've heard, for our field, and that the role of infrastructure organizations, especially those focused on advocating for the field as a whole, is especially critical. So if you are a nonprofit or a foundation, you're not already a member of Cal Nonprofits and or your regional grant making association or state grant making association, now's the time to join forces with thousands of your fellow leaders with a membership today. As always, we are stronger together. I want to thank everyone for spending this time with us. Take care, and we will see you next time. And thanks again to Carl and Shirley for joining us.